I've had a few videos where I've unpacked factual circumstances that the DOJ got wrong in its analysis of the Phoenix Police Department. I've shown you examples where the DOJ fabricated interview quotes, misstated factual circumstances behind police incidents, and I showed where they ignored the law. This week, the Ninth Circuit joined me in pointing out, yet again, where the DOJ report into the Phoenix Police Department got things wrong. Today, I'll discuss Puente versus the City of Phoenix, a 2024 published opinion where the Ninth Circuit upheld the Phoenix Police Department's handling of a protest response and the legal standard that exists when police officers confront unlawful behavior during demonstrations. I'm Steve Serbalik, and I'm a panel attorney for ASCOPS in Arizona. I'll actually start with how the DOJ characterized the facts behind this case. Here's the screenshot of page 75 of the DOJ report for those of you who want to pause and take a look. But the summary is that on August 22nd, 2017, after then President Trump held a scheduled rally at the Phoenix Convention Center, protesters became violent. Phoenix had intelligence that Antifa members were present and that there was a potential for violence or vandalism, or both. And violence did occur. Members of the crowd threw water bottles, and the police warned the crowd to remain peaceful. Suspected Antifa members moved towards a barricade fence and put up large signs that could be used to block the view and to allow them to potentially breach the fence. Then suspected Antifa members began pushing the fence. This prompted an order for officers to fire pepper balls at the ground in front of the suspected Antifa group. Some of the individuals backed away, but others did not. A member of the crowd threw a device that emitted unknown gas towards officers. Police officers donned gas masks and then deployed inert smoke canisters. A member of the crowd threw some sort of pyrotechnical munition at officers, prompting the Phoenix Police Department to decide this was an unlawful assembly. The police approached threatening or aggressive individuals and used a skirmish line and used pepper spray and pepper balls targeted both generally and at specific individuals that were threatening or aggressive. After the event, then Police Chief Jerry Williams had a press conference. She noted that there was limited damage downtown, and she expressed her belief that officers handled the crowd successfully and professionally, and that all in all the event was successful. She later stated that the department's conduct was textbook perfect. But later, groups sued the department, arguing that the department had unlawfully used force that impacted peaceful protesters, and the DOJ bought that narrative. But the Ninth Circuit, in evaluating this circumstance, made it clear this dispersing the crowd in this situation was lawful. The Ninth Circuit held that the use of chemical irritants, flashbang grenades, and other methods that are intended to disperse a crowd and not directed at a specific individual does not constitute a seizure within the meaning of the Fourth Amendment. In other words, if the officers aren't shooting at a specific person, the use of gas or flashbangs is evaluated differently. The Ninth Circuit analyzed this circumstance under the 14th Amendment and found that the department's conduct would need to shock the conscience, and officers would need to be acting with deliberate indifference with regard to any harm to protesters. But if, on the other hand, the situation at issue forces officers to make snap judgments, then the shock the conscience standard is only met if the police act with a purpose to harm for reasons unrelated to legitimate law enforcement objectives. In analyzing this protest response, the Ninth Circuit found that the protest violence escalated quickly and became dangerous after individuals threw an unknown gas canister and a pyrotechnic device towards officers. Therefore, the court found that there could not be an improper purpose to harm when the officers decided to use chemical irritants and flashbangs to disperse the crowd. The court also found that the challenge coins circulated afterwards, while distasteful in their opinion, had minimal relevance to its analysis. The court also took a look at the specific protester claims that when they were hit by projectiles like pepper balls, this was an unconstitutional use of force. For example, one protester who was shaking the fence was hit several times by pepper balls and argued this was excessive. Again, the court disagreed with the claim that this use of force was unconstitutional. The court recognized that shaking the fence was not a crime, but that the police were responding to the severity of the security problem at issue. And police could respond to this security threat even before issuing verbal warnings. Another protester was hit with a projectile after she remained in the area after police had announced an unlawful assembly. The court similarly held that police can use pepper spray and other irritants to disperse individuals in this circumstance. Regarding the First Amendment claims of protesters that Phoenix violated their rights to assemble, the Ninth Circuit addressed them as well and found that the Phoenix police acted lawfully. The standard that must exist, according to the Ninth Circuit, is a, quote, clear and present danger of riot, disorder, interference with traffic upon the public streets, or other immediate threat to public safety, peace, or order. In other words, there is no right to interfere with traffic by remaining on public streets. And there certainly isn't a right to riot or otherwise interfere with public safety. The Ninth Circuit also analyzed Phoenix police protest response policies and found that they were constitutional. So boiling this all down, the Ninth Circuit held what I've maintained all along. While police departments are sworn to protect the rights of individuals to peacefully protest, if the protest becomes violent or if protesters interfere with traffic on the streets, the police may constitutionally use reasonable force to disperse a crowd and arrest offenders. Then Chief Williams was right to publicly defend the actions of the Phoenix police officers who did their best to maintain public order. And the DOJ's report finding otherwise is dead wrong. Many of the supervisors on scene during this protest are ASCOPS members, and we appreciate their efforts to uphold the law. Hopefully going forward, police leaders will join us in recognizing publicly the work that officers do on the front lines. And on a personal note, I'll continue to work with ASCOPS to defend the rights of our members and to educate the public and police leaders on what the law actually is, particularly when the DOJ gets it wrong. If you have any questions or comments, please leave them in the comment section down below. Don't forget to like, follow, and turn on notifications. It really helps the channel grow. Be on the lookout for new videos. They come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Cerbalic. Thanks for watching. Stay safe out there.
Call back for 86. Negative.